Hi everyone, my name is Maya Farfin. I'm a marketing major at Florida State University and I'm new to the channel. And today I attended my first hearing for the Donna Adelson case here at the Leon County Courthouse. And we're going to go back to the studio to give you guys a summary on Deep Dive True Crime about the case.
At all of what happened here. Some of the matters we want to discuss are still under seal and are kind of.
Yeah, I mean, these lawyers are basically just going to do their own depositions.
This morning, State versus Donna Adelson, 2023 CR 3226. Parties can make their appearances for the motion here.
Georgia Cappleman from the state.
Josh Cappleman on behalf of Mrs. Adelson.
Fulford, Mrs. Adelson.
Right, we're here this morning on the defendant's motion to take additional depositions. Before we get into the argument on the motion, did the parties receive all of the orders that were filed last week on Friday?
I believe so, Your Honor.
I believe so as well, Your Honor.
Right, concerning the issue of the matters that have been filed under seal, I did not see on the docket where redacted copies have been filed. What is the issue with compliance?
Your Honor, about 12:30 on Wednesday, I did a notice of filing redacted copies of those documents and filed those. I have am I on it made it to the docket yet?
Ms. Cappleman?
I did receive the defense's redacted copies, Judge. I'm not seeking any redactions of any kind of stuff.
Very well. The clerk then is to unseal the response of the state. In total, go ahead.
The defense in our notice of confidential information in the court file that was also filed on Wednesday about 12:30. Also included after the state indicated that they were not going to be redacting anything, we included some language in the state's response in our notice of filing confidential information that is specifically referred to items that Your Honor has or received. And I'd rather not say in front of the media what that language is.
Then I will contact the clerk and see what the issue is with these items making their way to me. So that way this can be reviewed before it hits what is a public document. You may proceed with argument of the motion.
Judge, can we clarify what we're here on today? Is it the amended motion to take depositions?
Motion to take additional depositions that was filed on 4/29.
Yes, sir.
We filed an amended motion, Judge.
When was that filed?
It was filed on May the 7th.
Well, a copy of that sent to my office.
I don't specifically remember, and there's been a lot of things going on this week with my family that I might not have sent that directly, but I have a copy if you're on like please.
It had been trial all week long, so if it was not sent to my assistant, I probably did not see it in document. Cappleman, have you reviewed the amended motion?
Yes, Your Honor.
Are you prepared to argue this morning?
Yes, sir.
Please move forward, Ms. Fulmer.
Thank you, Judge. There are no significant changes to the amended motion, just more argument regarding the old investigation versus the new investigation. With respect to the new investigation, the state has indicated they have no objection to our taking of the depositions of Pat Stanford and Mr. Corbett. As to the new investigation, they continue their objection to taking depositions regarding the old investigation of Mr. Corbett, Mr. Sanford, and witness Robert Adelson. As to the old information, Your Honor, in light of the new investigation, specifically as to Mr. Corbett, the action that he took and the representations that he made in the new investigation certainly call into question what he did in the old investigation in a very material way. because of representations that were made to Your Honor and another judge in this case are false. And the warrants were issued based on false information. And the manner in which he conducted his investigation and came to his conclusions on the whole investigation certainly need to be revisited. With respect to the objection that we cannot take depositions regarding the whole investigation as to those 3 witnesses, it just frankly seems illogical. Mrs. Adelson hired and paid counsel, conflicted counsel, to represent her. They had investigations conducted, they took depositions, they conferred with our client, they have work product, none of which we have available to us except for deposition transcripts that we took out of the public record. My best example I can provide is there's a witness in this case to be called by the state named Catherine McBanwell, who's already been tried and convicted. And the depth of the conflict between Mrs. Adelson and her prior counsel, this court is not even aware the significance of that conflict. The court is only aware of the surface of that conflict. So if Catherine McBanwell, who wants to testify in this case, and testify against Mrs. Adelson and plans to, or wishes to at least, receive a significant reduction in her sentence for testifying against her, what's really being asked of current counsel for Mrs. Adelson is we rely on someone like Mrs. Vanawat's counsel to take the deposition of these witnesses, and we're stuck with that. They had a conflict when they were asking questions. Why they did ask certain questions, we don't know. Why they didn't ask certain questions, we don't know. But we have a right, because we're conflict free, to now take the depositions of those witnesses and obtain the information that we believe we need to know to adequately represent her in trial. We don't intend to go in and ask the same questions of what's been asked before. It's been asked by prior counsel that's conflicted in this case and by other lawyers or other defendants in this case. That's not our purpose. But we certainly have a right to inquire into what we want to know to represent her adequately at trial. So that is our request. The state objects, but we're asking Your Honor to order us opportunity to take depositions that are not conflicted counsel.
Cappleman, you may respond.
Yes, Judge, Ms. Fulford has accurately stated the position of the state, which is we do object to redeposing witnesses that have been deposed by previous counsel for this defendant, the witnesses about what it is they would say at trial, which I feel was adequately done previously. I'm not aware, I didn't follow the example of Catherine McBanwell. We did do a deposition of her with these lawyers. Did not find it to be anything new that hadn't been asked of Ms. McBanwell many times before, but since Ms. Adelson had not deposed him before, we did do that deposition, and we have done several others that have been exactly what those witnesses have been asked before. So I would continue my objection to redeposing witnesses on the same materials they've been previously deposed on by this defendant. If it's something new, great, let's depose them on that. That is not a waste of everyone's time, and I have no objection to that.
The issue that you're raising with the conflict is an interesting one, but it also comes down to a matter of timing. Based on what the prior counsel represented to both the court and I believe to the state as well, is that any conflict that he had with Charles Adelson was resolved up until a certain point. Because the conflict presented itself when the jury was to be selected, at that point the trial could not continue. But while Mr. Adelson had given his consent or waived any conflict with the representation later of his mother, as to that, how exactly, when your client chose that particular counsel, how in effect is that prejudicing her as it relates to the depositions that were taken?
I would need to get my client's permission to disclose the additional conflict.
Well, based on what has been argued today, I will take this under consideration. As to the rule for discovery depositions, I believe the case is interpreting this, leaves it in discretion of the court if good cause is shown. Additional depositions of witnesses who have been previously deposed may be deposed again. I believe as to the matters that are undisputed, if there are deposition topics that cover new information, certainly you are free to depose, and the parties are to coordinate those depositions. As to other matters, if you believe this requires an in-camera hearing, this needs to be set up fairly quickly. Any other matters that either party needs to address today?
No, Judge.
No, Your Honor.
Well, that brings a conclusion to the hearing for this morning. We are in recess.
Thank you, Your Honor.
Judge Stephen Everett held a hearing today, Friday, May 9th, in the Donna Adelson case that I had the pleasure of attending, on the defense's amended motion to take additional depositions. As you likely already know, the case is no longer going to trial in early June. Instead, because of a recent investigation through which the state gathered additional evidence that it will be using against Donna Adelson, an emergency motion to continue the trial was granted last week, with jury selection starting on August 19th. Okay.
That was really good. I mean, amazing.
Thank you.
A+. So now you can just.
Okay. So, the main issue in the hearing today was the defense's request to redepose 3 witnesses: Robert Adelson, FBI Special Agent Sanford, and Sergeant Corbett, the state's cell phone expert. The defense and the state agree that the defense can take the depositions about the new investigation that recently concluded. However, the defense and state are in disagreement about redeposing these witnesses about the original investigation onto Donna Adelson and the murder for hire. The state objects because Donna Adelson's prior counsels, Alex Morris and Dan Rashbaum, already deposed these witnesses in Donna's case. Thus, the state sees no reason for them to be redeposed by Donna's new lawyers. The defense claims that the conflict of interest surrounding Dan Rashbaum is a lot more severe than the case knows. But the attorney, Jackie Fulford, refused to provide any detail, saying that she had to get the consent of her client, Donna, to reveal the full depth of the conflict of interest. Jackie Fulford then argued that it is illogical to preclude Donna's conflict-free counsel from redeposing these witnesses because they, as conflict-free attorneys, have additional questions that they want to ask witnesses about the original investigation. Ms. Fulford also argued, with respect to Sergeant Corbett, that his involvement in the recent investigation calls into question some of the representations he previously made to the court, to Judge Everett and a prior judge on the case, suggesting that he has made false representations. It was unclear whether this was in reference to the new investigation, perhaps statements from Sergeant Corbett contained in a probable cause affidavit, or with respect to his prior testimony. A lot remains unclear because so much is being filed under seal. In fact, this commentary is being made without having access to the defense's amended motion to take additional depositions. Thus, our analysis may be mistaken, because we do not have the full context to properly interpret what was being said at the hearing. We are doing the best we can under the given circumstance. Anyway, Ms. Fulford insisted that she and Mr. Zellman should be allowed to redepose these 3 witnesses without any limitation. The state insisted that the witnesses were deposed by Donna's prior counsel, and they can only be deposed about new facts. The judge's ruling was a bit hard to follow, particularly because we do not have a copy of the pending motion. He seemed to take the motion under consideration, meaning he will issue a ruling soon, but he also hinted at his ruling. He noted that the discovery rule allows redepositions when good cause is presented, particularly to cover new issues or facts. He also suggested another option for the defense, in case the defense wants to explain its need to redepose certain witnesses because of the more significant conflict issues that they hinted at with prior counsel. Judge Everett suggested to the defense that they could request an in-camera hearing where the public and media would not be allowed, for the court to consider the additional information that Ms. Fulford hinted at regarding the conflict of interest between Dan Rashbaum and Donna Adelson. We will keep an eye on the docket and bring you an update when the court rules. Judge Everett also addressed another issue regarding the unsealing of several motions and responses that were originally filed under seal. It seems that we will soon have access to those records, but that they will be partially redacted.
Outside of the courtroom, we caught the end of a brief interview Prosecutor Georgia Cappleman gave to Tallahassee Democrat reporter Jeff Berlew. We will show that to you shortly. The most interesting part, to us, was Ms. Cappleman's response to the inquiry about whether she agrees with Ms. Fulford's representations about the falsity of statements contained in the probable cause affidavits previously submitted to the court. Her response was that she disagrees that they are false. Okay, coming soon is our first look preliminary analysis of the 84-page initial brief filed by Charles Adelson in his appeal. We hope to see you there.
Elaborate at all on what happened here. Some of the matters we want to discuss are still under seal and are kind of.
Yeah, I mean, these lawyers are basically just going to do their own depositions of the witnesses that previously employed by prior counsel representing this same defendant. So the state's objective as a waste of time, the reasons. All the same stuff. People have already testified about these things. People have previously posted about these things. We just kind of want to move forward and get things going, not waste a lot of time.
Okay, can you say anything about this recent investigation that kind of remains under seal? Details of it. Okay.
Any position on the claim that everything in the affidavit seeking the permission to record was false?
Yeah, my position is it's not false.
Okay,
Okay.
thank you.
Great, thanks.
Thank you. Good question.
Yes.
As always, thank you for watching us here at Deep Dive True Crime and our sister channel, ML Justice Network. I look forward to working here this summer and learning more about the law and cases we cover, and I hope you join me for this wild ride.
Hi everyone, my name is Maya Farfin and I'm new here to the Deep Dive True Crime YouTube channel. Today I had the pleasure of witnessing the Donna Adelson case here at Leon County Courthouse. To tell you a little bit about myself, I'm currently a marketing major at Florida State University and I'm going into my sophomore year. Today was my first court experience and we're going to go back to the studio to give you guys a summary.
Good.